Hello, this is Matt on the Moon Lambo channel, and in more The SEC Hates You news, we get this fun headline from you today. SEC claims XRP holders are too partial, citing physical violence references. The SEC is actually arguing that attorney John Deaton, who is seeking to intervene in the SEC versus Ripple case on behalf of 17,000 XRP holders, they're claiming that John Deaton is threatening physical violence. That is ridiculous, and I'm going to flesh it all out for you. There's that and oh so much more here. There's lots to talk about because look, this the SEC, they were firing back at most recently. So that, what they're citing here, this document was the SEC firing back at what Ripple said in response to John Deaton's motion to intervene in the case in the first place. And so the SEC already made their response to John Deaton as to why it doesn't make sense for the 17,000 XRP holders and John Deaton to be able to intervene. And in a video I put out very recently, I just put it out, I highlighted John Deaton's response to that, which came out on May 17th, the same day that this from the SEC also came out. And so just to be clear, this is not in response to what John Deaton wrote. This is in response to what Ripple wrote, which was in it sounds convoluted, right? Which was in response to what John Deaton wrote in terms of the just motioning to intervene in the case here. And so I've got some interesting stuff, but look, before I go any further, I do want to be clear, I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you should not buy or sell anything because of anything I say or write. I'm really nothing more than an enthusiast who enjoys making YouTube videos as a fun hobby about Ripple and XRP and crypto, but that is all that's going on here. And so before we even get into some of the nuts and bolts here, I want to go ahead and highlight this some comments from attorney James Filan, who is not involved in the case, but he's a member of the XRP community, and so he's become pretty well known, I'd say. He's been sharing his perspective on all sorts of things, and I think he just absolutely nailed this. So even before getting into additional specifics, I want you to hear this, because it kind of sets a proper tone for the remainder of this video. So this is what attorney James Filan had to say. The SEC has filed another objection to the motion to intervene. The SEC's mission statement is, among other things, to protect investors. The SEC has argued from the beginning of this enforcement action that XRP is a security, thereby arguing that XRP holders are actually XRP investors. And by the way, that distinction from a legal perspective is important. For me and you, probably not, because like to me, whether you call me an investor or a holder just in day-to-day life, functionally, I could not possibly care less. But it turns out there's a legal distinction here, and it's worth being aware of that. So again, with the SEC's mission being to protect investors, well, whether or not somebody has XRP as a holder or an investor, which has legal implications behind it, that actually functionally matters here. So anyway, in its latest filing, it attacks XRP holders. It says, because movements, and by the way, to be clear, when they say movements here, they're talking about John Deaton and the 17,000 XRP holders who are not okay with what the SEC is doing. That's the reason they're seeking to intervene. So anyway, it says, because movements are not seeking to appear as objective friends of the court, but rather to advance their own interests, to pursue claims against the SEC, defendants request that movements appear as amici should be denied. And so amici, I might have it highlight. I would do it somewhere. I can't just rapidly recall where, but amici. So what they're talking about there is it's a technical legal term for some sort of intervention in the court, so that the movements, the 17,000 holders along with John Deaton, you can intervene under amici, and there might be another word to it, amici something or other, curiae, something like that. I'm not a lawyer. I'm not pretending to be. Look, I just play one on TV. But this would mean that you could only intervene in some sort of limited capacity, right? That's what that is. So anyway, let me just read that again now that I keep it track. So it says, because movements are not seeking to appear as objective friends of the court, but rather to advance their own interests, to pursue claims against the SEC, Defendants request that movements appear as amici should be denied. And so now James writes the following. Attorney James Filan. It's clear that the SEC is antagonistic toward XRP holders and has no intention of protecting them or advancing XRP holders' interests, which leads to only one conclusion. The enforcement action brought by the SEC has never been intended to protect anyone or anything. Its only objective has been to destroy XRP, XRP holders, and Ripple. The SEC is horribly misguided and needs to end this travesty. Well stated, James Filan. And so if you look here, again, the headline from you today, SEC claims XRP holders are too partial, citing physical violence references. Oh, we'll get to the physical violence stuff here. But first, I want to read something I've got to, if you can hear that. These are dead trees I've got in my hands, and oh my gosh, it was a slaughter. It was definitely a slaughter. This document actually wasn't that bad, 15 pages. But some of these things are upwards of 100 pages, so only 15 trees worth of... only 15 pages worth of trees were actually slaughtered for this one, but I highlighted the parts I wanted to cover, which actually, thankfully, despite reading this whole thing, there were only a couple spots I actually wanted to highlight, because most of what the SEC stated in this, it's just another regurgitation of what they've already stated before. It really is. It's like in terms of what the SEC, because mind you, the SEC, what I've got in my hands here, this is a response to what Ripple had to say about John Deaton's proposed motion to intervene. But the SEC already responded directly to John Deaton, and so there's tremendous overlap. So it's just another regurgitation of that. But I did want to highlight part of what they covered in their preliminary statement. So this is the SEC and their most recent legal filing, being a bunch of asshats. As described in the SEC opposition, movements cannot offer any unique perspective or information that is not already available to the court, either in the public record or through the presentation of defendants' able counsel. So let me pause right there. Movements cannot offer any unique perspective or information not already available to the court. I already shredded that in the video where I broke down Attorney John Deaton's incredible response to the SEC. I mean, that's just clearly not true. Frankly, and this is not a dig against Ripple, but they're just not equipped to handle some sort of defense of the entire XRP ecosystem, of which, mind you, it's so big and so vast that there's no way that they could, especially given their focus on defending Ripple, like their company themselves, they don't know everything that's going on, nor should they have to. And so you've got 17,000 holders that would like to drop the science on them, and the SEC doesn't want the investors that it's supposed to protect to have a voice in this damn case here, which is pretty disgusting to me. Right? But it's just funny that the SEC, while their mission is supposed to be to protect investors, they're stating that the investor's perspective is already sufficiently defended by Ripple. Think about that. So they're saying that their investors, the SEC, the investors they're supposed to protect, are actually adequately defended by Ripple, not the SEC. That is astonishing. Anyway, the SEC asshats continue. Back to the document here. Nor are movements impartial, objective participants seeking to aid the court. Rather, they have wholly adopted defendants' litigation positions and advocate for the same outcome as defendants. I gotta pause there again. That's an outright lie, and the SEC knows it. They are not wholly adopting Ripple's legal position. Absolutely not. When has John Deaton come out and made it clear that the mission of himself and the 17,000 XRP holders is to prove that XRP sold in 2013 back then was not a security? Of course that's not the case. In fact, John Deaton has said maybe it was a security back then, but it sure as hell isn't right now. And so to say that there's their words here, they've been wholly adopted defendants' litigation position, they know that's not true, and they are not afraid to lie to the court. But these judges are not stupid. So you just gotta wonder, how are they this flagrant about the way in which they're misrepresenting and outright lying what others have stated when the record is clear? It's just offensive. Really grinds my gears, folks. Really grinds my words are see how ground up my gears are. I can no longer functionally make sentences. I need to step it down now. Anyway, so back to what they were writing here, what they wrote here. Seeking, where was I? I think it was this for. Yeah, okay, so I'll just read. This is the last sentence I read. Rather, they have wholly adopted defendants' litigation positions and advocate for the same outcome as defendants. Seeking to inject themselves as third-party defendants in this action, movements would act as friends of defendants, not true friends of the court, if permitted to participate. Think about that. The SEC, which is supposed to have the interests of investors in mind, is acknowledging here that that the holders, and this is just one of many times they've done this, acknowledging again that that frankly there's more overlap with what Ripple and the 17,000 XRP holders want to occur. Now again, there's some overlap. Happy to acknowledge that. But my gosh, the perspective of the 17,000 holders and John Deaton versus Ripple, it is not the same. And I've already broken that down, so I don't think I want to do that further in this video. Then there was also this, and this was an interesting claim. This is on page 13 of 15. This is what the SEC wrote. Defendants seek, so talking about Ripple, defendants seek to use Amici to make an in-run around the court's discovery restrictions and rules of evidence. And so there you go. What a bogus claim right there. So the perspective of the 17,000 XRP holders is some sort of trick to work around the discovery rules that have been set in place. Because again, if something's discoverable, it can be argued and discussed in the court proceedings. Otherwise, it cannot. And so the claim here is that the 17,000 XRP holders and John Deaton, they have a bunch of stuff that wouldn't necessarily otherwise be discoverable, and so Ripple just wants John Deaton and 17,000 holders to be admitted, at least in limited capacity, just to work around the system. What the hell kind of bogus claim is that? Is a judge really gonna fall for that? That's the stupidest damn claim. All right. Into this article now. This is from You Today. SEC claims XRP holders are too partial, citing physical violence. The U.S. Securities and Exchange Commission has filed another reply memorandum of law opposing XRP holders' intervention in the Ripple case. The agency states that they cannot appear as amici curiae, which means friends of the court, because they are too partial and their interests align with those of the defendants. Movement's counsel, John Deaton, is also being accused of attacking the SEC. And here's a quote. And Movement's counsel uses profanity and references physical violence in publicly attacking the SEC and its staff. Okay, let's talk about this. So this was actually, John Deaton actually addressed this in his response to what the SEC stated in his it's so convoluted. So John Deaton, he recently filed a motion to intervene in the SEC versus Ripple case. The SEC responded to that with their list of reasons why that shouldn't happen. John Deaton then responded to that, which is the video that I covered very recently, because John, he masterfully crafted this 15-page document, just tearing apart the SEC's arguments, citing very easy to understand terms, the way in which the SEC is deceiving the court. That's their goal anyway. They're attempting to deceive the court. And so part of what he wrote about, which I did not cover in that video because that video was already over a half hour. Like I had to stop somewhere. But he did come back at this because the SEC is making out like John Deaton is some sort of like, I don't know, violent maniac. It's ridiculous. It's a bogus claim. So, but now I'm holding this is a different set of dead trees you're now hearing. Different set of dead trees. This is the dead trees that made it possible to print up John Deaton's response to the SEC, which again I covered, but this portion I did not cover, and now I'm going to because it's brought up again by the SEC and it's completely bogus. And so there was a portion of John Deaton's response to the SEC in which he was talking about how there are, let's just say, some not so good optics in terms of former SEC chair Jay Clayton, as well as former SEC director William Hinman. I'm assuming a lot of you know at this point. I'll just try and be brief for those that are unaware. There's some things that have unfolded that certainly at a minimum give the appearance of impropriety, such that money has actually flowed to William Hinman, for example, and he happened to, from a law firm that he used to work at. While he was at the SEC, though, more money flowed to him, and he said things and created policy that benefited his law firm, which he previously worked at, while they were paying him after he stopped working there, having to do with the SEC's position specifically on Ethereum. Then he left the SEC and went back to work for the law firm. So, there's an example. And so John Deaton brought this up. And then he wrote... In regards to that, he wrote the following. So these are now John Deaton's words in his response to the SEC. Regardless of whether there was wrongdoing, XRP holders became outraged. Attorney Deaton explained that issues of sovereign and qualified immunity could result in the inability for any party to depose the prior SEC leadership. After witnessing XRP holders' disappointment and feelings of injustice, Attorney Deaton attempted to provide a satirical, humorous, exaggerated mock cross-examination of former Chairman Clayton, incorporating special effects and humorous scenes from the iconic lawyer movie My Cousin Vinny. Satirical mock cross-examination. So for the SEC to use the above scenario and imply or suggest that Attorney Deaton was promoting violence or drug use is sad and pathetic. It is a clear attempt to cast Attorney Deaton in the most unfavorable light, hoping that it will have a negative impact on the motion to intervene. Attorney Deaton is a former Special Assistant United States Attorney, adjunct law professor, mass tort product liability lawyer, and a medically retired Marine Corps judge advocate who has been awarded significant military honors and medals, including from the President of the United States. Attorney Deaton stands on his service and record to his profession and to his country, not from being, quote, popular on Twitter for his efforts, end quote. The implication or suggestion that Attorney Deaton's criticism of the SEC's enforcement action against XRP are unfair and unfounded flies in the face of reality. And indeed, his video is pretty funny, actually. I'm sure some of you listening have seen it, but John Deaton, he's got a YouTube channel. I don't know that he's posted anything since then. I checked somewhat not too long ago, and I hadn't seen anything else anyway. But yeah, it was a funny video, clearly a joke. And then the SEC takes what is clearly a joke and then makes it out as if John Deaton's a maniac. I don't know who's going to fall for that, though. These judges, again, they're not stupid. It's like they're just thinking of every argument they can that sounds bad for John Deaton and then just hoping it all sticks. It's just you'd have if I'm the judge, I'm feeling insulted at this point. Like you're like, you think I'm stupid enough to believe your argument. That would be my response. It's like, serious. I mean that very sincerely here. It's just completely absurd. And so this is what we're dealing with here. Also worth noting too, the SEC, they're saying that if ultimately the movements, the 17,000 XRP holders, are allowed to intervene in the case, that the SEC is threatening. They are actually threatening to extend, they're threatening to request an extension of the discovery process by 4 months. Okay, whatever. I mean, it doesn't mean that they'd get it. I don't even know if that's just, but they're just like whining up a storm here. You want some cheese with that line? Freaking SEC asshats, man. That's the sound of the SEC asshats marching along. It's annoying. That's an annoying sound. I'm sorry you had to hear that. So anyway, now you're all caught up. The rest of it, seriously, I'm not kidding you. It really is just almost 100% a regurgitation of stuff the SEC has already said. So I'm gonna keep the regurgitation down to a minimum. But I'll wrap up there. I'm not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.